I want you to picture something for a second. It is I mean, it's a classic image. Maybe a bit dramatic, but stay with me. Picture a fortress.
Okay, I am picturing it.
Yeah, so I am talking massive stone walls, a drawbridge, a moat filled with, I don't know, crocodiles, the whole medieval setup.
Right, the whole impenetrable castle vibe.
Exactly. Now imagine that inside that fortress is everything you have ever worked for. Your house, your savings, your family's future, your business.
It feels incredibly safe.
It does, right? Like absolutely nothing can touch it.
It is a very comforting image. It's what we all want to believe we have built for
But
ourselves.
the terrifying question we are tackling today is this. Are those walls actually made of stone?
Or did you just paint a cardboard box gray and, hope nobody leans on it?
And that right there is why we are doing a deep dive today into the world of South African trusts.
A very necessary deep dive.
Now I know what you might be thinking. You are thinking, trusts. Isn't that just for the Elon Musks of the world? Or people with private islands?
Or maybe you are dreading 20 minutes of dry legal jargon.
Which, to be fair, is a pretty normal assumption when it comes to this stuff.
Usually, yes. But you really need to stick with us today.
Because what we found in the research is that a trust, when it is actually done right, is literally that asset protection fortress we just imagined.
It is not about being a billionaire. It is purely about survival.
Absolutely. We have gone through a massive stack of legal analyses today on trust validity in South Africa, some really eye-opening court cases, and we are leaning heavily on the insights of trust consultant Lumka Sturman.
Her framework is fantastic for this.
It really is. And our mission for this deep dive is to debunk the biggest myth out there. The idea that a trust is just a folder of papers you sign once, shove in a bottom drawer, and completely forget about.
Because if you do that set and forget thing, you are setting yourself up for a very rude awakening.
We are talking about how to actually build a financial legacy that lasts. And honestly, some of the horror stories in these sources, they genuinely gave me chills.
They are stark warnings. But there is a massive upside if you get this right, and we want to focus on that.
Yeah, we definitely don't want to just scare people today. The positive outcomes of a correctly structured trust are just incredible.
They really are. So let's unpack this from the ground up.
Let's start with the core concept. Why do we even have trusts in the first place? Like, why go through the hassle?
Lumka Sturman actually has this phrase in her materials that perfectly encapsulates it. She calls it separating ownership from risk.
Separating ownership from risk. I really like that.
It is the fundamental principle of everything we are talking about today. Think about it this way. In the normal course of life, especially if you are an entrepreneur or a contractor or a medical specialist, you carry risk.
Every single day.
Exactly. You sign contracts, you might sign personal sureties for a business loan, you have employees, you even just drive a car on public roads.
You are basically walking around with a target on your back.
You really are. And if your business goes bust or you get sued for negligence, creditors come looking for assets to seize to settle that debt.
Right. And if those assets, my house, my investment portfolio, my cars, if they are in my personal name?
They are entirely fair game. They are attached directly to you and your risk.
Okay, so where does the trust actually come in and fix that?
A trust completely breaks that link. If those assets are housed within a legally valid trust structure, you don't technically own them anymore.
The trust owns them.
Precisely. The trust is a separate legal entity.
But wait, I can still live in their house, right? I can still drive the car.
Oh, absolutely. You control them via your role as a trustee, and you get to enjoy them as a beneficiary. But because you do not personally own them, your personal creditors generally cannot touch them.
So that is the fortress.
That is the fortress. The walls are that legal separation between you, the person taking the risks every day, and the trust, the entity holding the assets safely.
So it is not just about, hiding money in some shady offshore account. It is about ensuring that one bad business decision doesn't wipe out your family's home.
It is purely defensive structuring. And the sources are very clear that this is not just for the ultra-wealthy.
It is for small business owners.
Doctors, engineers, graphic designers, anyone who has built some wealth and wants to ensure they actually keep it.
Now, beyond just the protection side of things, there is the money side, the tax efficiency.
The numbers here are compelling.
I saw the figure 20 to 25% thrown around in the notes regarding estate duty. Can we break that down? Because losing a quarter of everything sounds insane.
It is a massive chunk of wealth. When you pass away in South Africa, the government levies an estate duty. It is effectively a tax on your total net worth at death.
And it starts at 20%.
It starts at 20%, and for larger estates, it actually goes up to 25%.
So if I have worked my entire life, paid income tax my whole life to build up a nest egg for my kids, the government takes a quarter of it right off the top before my kids see a cent.
If all of that is sitting in your personal name, yes, they absolutely do.
That is brutal.
It is. But if those assets are growing inside a trust, they do not fall into your personal estate when you die.
Because the trust doesn't die.
Exactly, the trust continues. So the assets sit outside the net for your personal estate booty calculation. You are legally minimizing that massive tax bill and leaving significantly more capital for your family's legacy.
Honestly, that alone seems worth whatever paperwork is involved.
Yeah.
But there was another major benefit mentioned that I had never really thought about before. The frozen account scenario.
This is the practical nightmare that almost nobody plans for.
Walk me through it.
When someone dies, their personal estate is frozen by law. The Master of the High Court has to officially appoint an executor to handle things.
And how long does that process take?
You would hope it's quick, but it can take months.
Months.
Sometimes even years if the estate is complex, or if the master's office is experiencing a backlog, which is common. And during that entire time, your personal bank accounts are frozen solid.
That is terrifying.
It is. Your grieving family suddenly realizes they cannot access cash to pay the mortgage or school fees, or even just buy groceries from those accounts.
You are dealing with the loss of a loved one, and suddenly your debit card is declining at the supermarket.
It creates chaos. But if the family's operating money and assets are housed in a trust, the trust just keeps operating.
Because the trustees are still there?
The surviving trustees are still there, yes. The bank account remains fully active. Business continuity is guaranteed, and the family has immediate, uninterrupted access to funds. It smooths out the absolute worst parts of the chaos of death.
Okay, so the why is incredibly compelling.
Yeah.
Build the fortress, save a fortune in taxes, keep the family afloat during a tragedy. It sounds like a total no-brainer.
It is, on paper.
Right, on paper. And here is where I need to push back a bit, because the legal sources also spend a lot of time talking about this concept of a sham trust.
Yes. This is where it gets tricky.
Honestly, reading through the case law, it feels a bit like the courts can just arbitrarily decide your trust is fake whenever they feel like it.
I can completely see why it reads that way, but it isn't quite that arbitrary. Though you were absolutely right to be skeptical. This is the reality check portion of the deep dive.
Okay, lay it on me.
For a trust to give you all those amazing protections and tax benefits we just discussed, it has to actually exist legally.
But if I have the signed papers in a file, doesn't it exist?
Not necessarily. A trust is declared a sham when the courts look at the situation and decide that the founder, the person who set it up, never genuinely intended to create a trust in the first place.
But intention is so subjective. How on earth do they prove what was going on inside my head 20 years ago?
They don't look at your head, they look at your actions. Think of it like this. If you buy a Rolex from a guy in an alleyway for $10 and it stops ticking an hour later, you didn't buy a Rolex, you bought a fake.
A very cheap fake.
Exactly. A sham trust is the exact same concept. It might look like a trust on the surface, but the legal substance just isn't there.
We have a story in the notes about a guy named David Richardson. This one really hit home for me because he didn't seem like some criminal mastermind trying to commit fraud. He just got sloppy.
David is the textbook tragedy in South African trust law. He set up a trust 20 years ago. He went to the lawyers, he signed the deed, he registered it, did all the initial steps right.
So he had the fortress.
He had the blueprints for a fortress, but then he treated the money inside it exactly like he did before the trust existed.
What does that mean, practically speaking?
It means he didn't hold meetings with his co-trustees. He didn't pass formal resolutions when he wanted to buy or sell trust assets.
She just did whatever he wanted.
He did. He even mixed his personal cash with the trust's cash in the exact same bank accounts.
Oh, wow.
He used the trust's debit card to buy his morning coffee and pay for his personal groceries.
So to him, the trust was literally just a different name on his personal checking account. It was still, quote unquote, his money.
Exactly. And when his business eventually failed and his personal creditors came knocking, they looked at this setup and argued that the trust was a complete fiction.
And the court agreed with him.
The court entirely agreed. The judge basically said, David, this isn't a trust. This is just you wearing a legal mask. They pierced the veil of the trust, and he lost his family home to the creditors.
That is so harsh. He lost everything just because he didn't hold a trustee meeting.
It is not just about skipping a meeting. It is about the complete lack of separation.
Mm.
Remember the core rule. The fortress relies entirely on separation of ownership and risk. If there is no real separation in practice, there is no fortress to protect you.
Okay, that makes sense. That is Sam trust. But then the legal texts mention this other term, the alter ego trust. How is that different? Because to a layman like me, they sound like the exact same nightmare.
It is a subtle difference, but legally a very dangerous one. A sham means the trust never truly existed because there was no genuine intention to form one. An alter ego trust, on the other hand, might be entirely valid on paper. It is a real trust.
Okay.
But one person dominates the administration of it so completely that the courts decide to look right through the legal structure.
So if a sham is a fake watch, an alter ego is a real watch that you're using as brass knuckles to hit someone over the head.
That is a brilliant way to put it. You literally kill the protection of the trust by controlling it too much. Let's look at the example of Margaret Campbell from the sources.
Right, Margaret Campbell. She was the sole trustee and the sole beneficiary of her trust, wasn't she?
Effectively, yes. She made every single decision completely alone. She did not have an independent trustee to check her power or provide any oversight.
So she was just having meetings with herself.
Basically. And when a massive family dispute arose and the structure was challenged, the court looked at how it was run and said, there is zero separation here. Margaret is the trust, and the trust is Margaret.
So her protection just evaporated.
Gone in an instant, because she could not let go of absolute control.
It really seems like the common thread running through all these failures is control. If you try to control the assets too tightly, you end up crushing the very protection you're trying to build.
That is the ultimate paradox of trust law. You genuinely have to let go of ownership to gain the protection.
So if holding on to control is the enemy, how do we actually prove to a court that the trust is real and valid? The legal texts talk about these three certainties. It sounds like something straight out of a fantasy novel. The three certainties of the fortress.
It does have a very mystical ring to it, doesn't it? But it is the absolute bedrock of South African trust law. If you are missing even one of these three certainties, you do not have a valid trust.
Okay, walk us through the certainties.
First is certainty of intention. You must actually mean to create a trust, and your actions must reflect that, not just your paperwork. That covers the sham issue we just talked about with David Richardson.
That makes perfect sense. Don't fake it, actually intend to do it. What is number two?
Number two is certainty of subject matter. The trust must own something specific. You cannot just create a trust that floats in the ether holding absolutely nothing.
You have to actually fund it.
You have to put actual identifiable assets into it. A house, an investment portfolio, shares in a company.
Got it. And the third certainty?
Third is certainty of objects.
Objects. That sounds weird. Like furniture. I hereby leave my favorite armchair to the trust.
It is very old legal speak. In this context, objects refers to the beneficiaries.
Okay. The people getting the benefit.
Exactly. The beneficiaries must be clearly and distinctly identifiable. You cannot use vague language in your deed like, I leave this to my good friends.
Because who legally qualifies as a good friend?
Exactly. It is entirely subjective. The trustees need to know exactly who qualifies to receive benefits. If the objects are vague, the trust fails.
Okay, so intention, subject matter, and beneficiaries. Those are the three pillars holding up the fortress. But then we get into the actual administration side, the paperwork. The sources talk about the registration trap, and this part honestly blew my mind, the story of the Thompson family.
This is a pure tragedy of administration. The Thompson family got all the advice. They sat around the mahogany table with their lawyers 15 years ago. They signed the trust deed, they clinked champagne glasses, they thought they had secured their family's future.
But they missed a step.
A critical step. They never submitted that signed deed to the master of the High Court.
Wait, I need to stop you there. So they had the physical paper, signed by everyone, sitting in a safe. Why wasn't it legally valid?
Because under South African law, specifically the Trust Property Control Act, inter vivos trusts, which are trusts you set up while you are still alive, they absolutely must be registered with the master.
So it's not a private contract.
No, it is not. Until the master's office reviews it, stamps it, and issues a formal reference number, legally speaking, that trust does not exist anywhere but in your imagination.
So for 15 solid years, the Thompsons lived their lives thinking they had a fortress.
They did. And when a major lawsuit finally hit them, the creditors walked right through the walls because legally, the walls were never built. The property they thought was safe was still deemed to be personally owned.
They were completely exposed.
Completely, they lost the assets.
That is just heartbreaking. It is a pure technicality, but it cost them everything they built. And speaking of the Master of the High Court, the sources emphasize this specific document called the Letter of Authority. Why is this one piece of paper treated like the holy grail of trusts?
Because it is. Think of the letter of authority as the trustee's official badge of office. Without it, you have zero power.
Even if my name is printed right there in the trust deed.
It does not matter what the deed says. The deed is just the rule book. Until the master officially issues that letter of authority with your specific name printed on it, you are paralyzed. You cannot legally act on behalf of the trust.
I can't even sign a basic contract.
You cannot sign a contract. You cannot open a trust bank account. You certainly cannot buy or sell a property. Any action you take without that letter is legally void.
Which brings us perfectly to the Wellington Trust case in the notes.
Yes, a very painful lesson in administrative reality. In the Wellington case, the parents, who are the original trustees, passed away.
And the children assumed they were next in line.
Because the trust deed clearly names them as the successor trustees, so they naturally tried to step in and manage the trust's investment properties.
But they hadn't gone to the master.
They had not been formally appointed by the master, and they had not been issued a new, updated letter of authority.
So what happened? The assets were just frozen.
Frozen solid for 18 months. The kids could not sell the properties. They could not access the cash investments. They could not even sign new leases with tenants. They did not have the badge.
18 months is a long time in finance.
And the market actually crashed while they were locked out waiting for the paperwork. They lost massive value simply because they lacked a single government document.
It really emphasizes that a trust is not just a financial product you buy off the shelf at a bank. It is an ongoing relationship you have to actively maintain with the government.
That is the perfect way to describe it. It is a living legal relationship. Which brings us to a concept I like to call administrative hygiene.
This was the real aha moment of the research for me, exposing the total myth of set and forget. I feel like so many busy professionals fall directly into this trap. You pay the expensive lawyer, you sign the fancy deed, you high-five, and then you literally never think about it again for 10 years.
And doing that is legally fatal. The source material lists several blaring warning signs that your trust might be practically invalid right now. Let's start with a simple one. Can you easily locate your original signed trust deed?
If the answer is, I think it's somewhere in the garage in a box marked miscellaneous, you might be in serious trouble.
Precisely. You need the original. Here's another warning sign. Do you have an independent trustee appointed?
This goes back to the alter ego problem.
Yes. For a family trust to avoid that alter ego label we discussed, where a judge thinks the trust is just an extension of you, you really must have an independent trustee.
So someone who isn't a family member.
Someone who isn't a beneficiary and isn't related to you by blood or marriage. Their job is to provide objective oversight and prove to the world that real, independent decisions are being made.
Just to prove someone else is actually looking at the books and agreeing with the choices.
Exactly. But perhaps the single most common and frankly the most dangerous mistake we see is the asset transfer gap.
The Harrison family example. This one actually scared me because it feels like such an incredibly easy mistake for anyone to make.
It is by far the most common failure point. Here is the scenario. The Harrisons set up their trust perfectly. They genuinely intended to move their investment properties into it for protection.
So they have the right intention.
They did. They even told their accountant that the properties were now in the trust. They went as far as writing it down formally in their trustee meeting minutes. They wrote, "We hereby move the beach house and the rental flats to the trust."
That sounds incredibly official. If I saw that in meeting minutes, I would think it was a done deal.
It sounds official, but in terms of property law, it means absolutely nothing. They wrote it in their minutes, but they never actually hired a conveyancing attorney to go to the deeds office. They never legally transferred the title deeds into the name of the trust.
So legally speaking, according to the government, the properties remained in their personal names the entire time.
Yes. In South Africa, the deeds office is the ultimate truth. If the title deed says John Smith, then John Smith owns it. It doesn't matter how many internal trust minutes you sign.
So when they eventually went to sell, or if a creditor had run a check on them, the entire asset protection fortress was just a complete illusion.
It was non-existent.
And imagine the tax implications of a mistake like that, too. You spend years thinking you have done all this brilliant estate planning, avoiding estate duty, and then boom, it is all completely undone because of a piece of paper at the deeds office.
It actually gets worse than that. If you just let the trust use the property or receive the rental income from it without formally transferring ownership, you might have accidentally created a massive tax nightmare with the Revenue Service, all while getting zero legal protection from creditors.
That is the worst of both worlds. And while we are talking about outdated documents, we have to mention ancient deeds.
Ancient, how far back are we talking?
Relatively speaking, ancient. The notes highlight anything pre-2001.
Ah, yes. 2001 is a very critical date in South African tax history. That is the year capital gains tax, or CGT, was officially introduced.
Before 2001, we didn't pay CGT on property sales.
No, we did not. So any trust deed written in the 80s or 90s was obviously not designed with capital gains rules in mind.
Because they didn't exist.
Right. Those old deeds often completely lack the specific modern clauses that allow trustees to distribute capital gains to beneficiaries to take advantage of lower personal tax rates.
So if you have one of these old trusts and you sell a property today, you might be paying way more tax than you legally need to, simply because the wording in your deed is 30 years out of date.
Exactly. You are leaving money on the table. And it is not just CGT. An old deed might not comply with newer, very aggressive tax laws like Section 7C regarding interest-free loans or modern FICA compliance rules.
So the rule of thumb is, if your trust deed is old enough to legally order a drink at a bar, it probably needs a serious checkup.
It definitely needs a review.
Okay, so let's just take a breath for a second.
Hmm.
We have firmly established that this is complicated territory. You've got the Master of the High Court, you've got SARS, the Deeds Office, the Trust Property Control Act. It is a total minefield.
It is extremely complex.
And honestly, trying to DIY your way through this sounds like a guaranteed recipe for financial disaster.
It is an unacceptably high risk to take with your family's future. And this is exactly why the role of a dedicated specialist comes into play. We spent a lot of time looking at the approach of trust consultant Lumka Sturman.
Now, looking through her website and her materials, what really stands out to me is how she positions herself. She acts as the bridge between just having a legal document in a drawer and actually operating a functional fortress.
That is a great way to view it. It is the difference between buying an expensive gym membership and actually working out with a professional trainer who corrects your form so you don't break your back. She ensures the legal structure actually performs when under pressure.
Because, let's be totally honest, most of us do not have the time or the patience to deal with the master's office.
No sane person actively wants to navigate that bureaucracy. It is slow and highly technical. Lumka's specific services seem purposefully designed to handle all that friction for you. I was looking closely at her foundation audit service. That really seems like the mandatory starting point, right?
Yeah, that caught my eye too. It is basically a deep dive risk analysis of your current situation. She looks at your existing structure, or lack thereof, and verifies if it is actually legally valid today.
To catch the mistakes early.
Exactly. Remember the Thompson family who forgot to register their deed for 15 years? A foundation audit catches a glaring error like that immediately.
It catches it before the lawsuit happens, before it is too late to fix.
And then for new setups, there is the blueprint service.
That is for the architectural phase. Designing the trust and the operating company structure properly from day one, ensuring that the company carries all the daily business risk and the trust safely owns the core assets, and making sure the legal link between them is airtight.
But the part that really spoke to me, especially considering all the horror stories we just went through about David Richardson and the sham trusts, is her annual maintenance service.
That is the real game changer for long-term protection. Handling the formal trustee resolutions, managing the ongoing SARS compliance, conducting what she calls fortress reviews.
It essentially prevents you from slowly drifting into a sham situation simply because you got too busy and lazy with your paperwork.
It is basically forcing you, as a professional, to maintain that crucial administrative hygiene we talked about earlier.
Exactly. And looking at her core value proposition, it is very clear it is not just a filing service. It is deeply rooted in education. Her materials constantly emphasize client empowerment.
She wants her clients to truly understand the strategy they're using, not just blindly buy a financial product. She explicitly says, "I am your missing key."
It is about ensuring you aren't just trusting a process blindly, but that you actually comprehend how your family's legacy is being protected from all angles.
Knowledge is the real protection.
And for the listeners who are sitting there right now thinking, okay, I really need to check if my fortress is made of stone or cardboard, she actually has a wait list currently open for her Asset Protection Fortress service.
Which is highly recommended. You can find all the details and join that waitlist at www.lumcasterman.com. Given the sheer complexity of South African trust law, getting that level of professional guidance isn't an expense, it's an investment in your peace of mind.
Absolutely. Because as we have clearly learned today, the ultimate cost of getting this wrong, losing your house, facing massive unexpected tax bills, that cost is infinitely higher than the cost of getting it set up right the first time.
If we summarize everything we have discussed in this deep dive, the ultimate takeaway is this. A trust is an incredibly powerful legal shield. It creates a lasting legacy. It legally saves you a fortune in tax. But it only works if it fully respects the three certainties and if it is administered with absolute ongoing discipline.
You have to respect the entity itself. You cannot just treat a legal trust like it is your own back pocket.
Exactly. It is a separate legal person in the eyes of the law. Treat it with the respect it deserves, and it will protect you and your family fiercely. Treat it with casual contempt, and the courts will tear it down without a second thought.
So here's the final provocative thought I want to leave you with today. Imagine a highly motivated creditor or an aggressive SARS auditor is aggressively looking at your trust structure right now, today.
They are actively looking for the cracks in the wall.
Exactly. If they look closely at your paperwork, your bank accounts, your meetings, would they see an impenetrable fortress? Or would they just see you wearing a slightly different legal hat?
That is the million-dollar question. And if you are even slightly unsure of the real answer to that, go dig out your files and check your letter of authority today.
Check the dates, check the names, make sure it's stamped, and maybe seriously consider reaching out for that professional review. Thank you so much for joining us on this deep dive today. We will catch you on the next one.
Goodbye, and stay protected.